right now, we have our guest joining us in person of Tomiwa Fadeyi, who is a legal practitioner, to discuss this important topic. Good morning, Tomiwa Fadeyi. Thank you for joining us on the Breakfast Cafe.
Good morning. Thank you for having me on Breakfast Cafe this morning. I'm happy to be here.
Thank you. Happy New Month.
Happy New Month too. Yeah, I almost forgot it was a new month until you mentioned it now.
It is a new
Thank you
month.
for that.
Yeah.
Thank you. It
So
is a new month.
this morning we're discussing the impact of social media on legal proceedings. I would like to kick off with this first question. As a legal practitioner, how has social media or social media evidence, changed the way legal terms or legal teams rather approach case preparation and evidence collection?
Well, thank you for that. We are in very interesting times, as everybody knows. Social media is, as we call it, a global village, and social media has affected virtually everything in the world today. Legal proceedings are not particularly left out. Although the legal profession, like I tell everybody, is a very conservative profession, that we do not exactly, by we now, I'm talking about lawyers, I'm talking about judges, I'm talking about stakeholders in the legal profession, do not exactly conform to, many of the, let me say, many of the modern changes that affect every other sector. But one way or the other, social media has forced its way into our lives. One way or the other, you get to see pre-COVID-19, there was almost nowhere in Nigeria where we used to partake in or we used to embrace what we call virtual proceedings. At this point in time, you'd realize that many courts, even now, the moment it is almost impossible to, the moment it is almost impossible to secure or procure the attendance of a party to the proceedings, many courts, many rules of courts, we have it in Oyo State, I am aware we have in Lagos State, I'm aware by the new rules of Osun State, many courts now embrace the idea of virtual proceedings in matrimonial causes, in land matters, and all of those. So social media has affected, social media has affected the course of proceedings when it comes to law courts and our legal affairs. You have also mentioned an important aspect of, you know, of the internet. I
Yeah.
don't want to restrict that to social media. When you talk about the Cyber Crimes Act 2015, I don't want to restrict it to social media because you realize that cybercrime is a big deal, especially in our country today. Over the weekend, there was a lot of issues that my attention was drawn to from X, formerly known as Twitter, and all of that. You realize that many people engage in cybercrime, cyberbullying, without even knowing that they are actually doing it. Many people are not even aware of the consequences of the action or the gravities of the offenses that they are committing. So by and large, there's been positive impacts, there's been negative impacts here and there, but you realize that as much as the legal profession is a conservative profession, one way or the other, social media has forced its way, the internet has forced its way into our lives as stakeholders in the legal profession.
All right, thank you for this. Now, this brings me to another question. They say social media is a projection of what we want people to see. So, which brings me to my next question. What type of social media evidence is most commonly used, and how are these evidence authenticated in court?
Okay, thank you for that. Now, when I saw the topic, I was going to, say one or two things about when you talk about evidence in law, I don't want to go into the nitty-gritties so that I don't bore you out. But when you talk about evidence in law, there is nothing per se, stricto sensu, that is known as social media evidence,
Okay.
right? We have different forms of evidence. We have documentary evidence, we have oral evidence, we have hearsay evidence, we have we have a whole lot of those. But there's almost nothing you would tag as social media evidence, stricto sensu, in that term, in that sense of the word evidence. The what I think you are referring to is, or what I may induce that you are talking about is when things happen on social media,
Yes.
and those things have to be discussed in courts.
In court.
Now, how do we go about this? A good example is the issue of cyber stalking, or the issue of cyberbullying, or issues of defamation. You see, there are two broad types of defamation now. There's libel, there's slander. Slander is by word of mouth. I'm just explaining it simply.
Yes.
Slander is by word of mouth. Libel is by something written and published, right? And there are elements of defamation. Now, let's take, for instance, Mr. Olumide publishes something about me that I find libelous, that I find defamatory on a platform like Facebook. Let's assume that sort of a thing is published on Facebook. What you get is that because what you published has to be one of the elements of defamation, is that apart from the fact that that thing is false, apart from the fact that that thing seeks to reduce my reputation in the eyes and mind of right-thinking members of the public, what you have to prove is the exact words which were published, the exact words we are complaining about as being defamatory. Now, if I take a screenshot from Facebook where Mr. Olumide published wrongly about me, and I want to attach it to what you would call my statement of claim in court, to say, this is what I'm claiming, this is what Mr. Olumide has done wrong, I'm claiming so amount, I'm claiming an apology, we are seeking relief from the court, I'm telling the court to bail me out. That screenshot in itself can come under the category of electronic evidence. Because it is electronically produced, it is electronically manufactured. The process of me taking a screenshot, the process of me attaching it to my claim, the process of me tidying it up and putting it in form of a document is what we call electronic evidence. Now, for a long time, until recent times, I think until, will I say 2011, I'm not sure, I don't want to call figures, but for a long time before now, electronic evidence did not actually have a place in our legal jurisprudence until recently. But what you get now is that by virtue of, the thing about laws is that laws are amended, repealed, adjusted, altered, and all of that. The Constitution presently has about 4 or 5 alterations. It's still the 1999 Constitution, but what you get is, as amended, there's the first alteration, second, third, fourth, and I think there's the fifth now by virtue of the election petition amendments and all that. Now, the law that actually guides evidence is the Evidence Act 2011. Now, by virtue of the enactment of that Evidence Act 2011, there is now as amended now, because it's been amended, I think in 2023, it's been amended. There is now what many lawyers, perhaps the most popular section of the Evidence Act today, Section 84. Section 84 is the section that actually provides for electronic evidence. The Evidence Act came to the realization that the drafters of that law came to the realization that, look, we cannot, in a world that is fast growing, now say that we do not want to have a place for electronic evidence. It's not possible, right? So what we are saying is the Evidence Act now provides in Section 84 that there is a place now for electronic evidence, for evidences that were produced electronically. But it says you must meet up with certain conditions. It says you must conform with certain terms, that you must show that the computer which you used has been used over the course of time, and so many conditions. But that is now recognized. All you have to do is to depose to, or to do a certificate, what we call a certificate of compliance, to show that you have complied with Section 84 of the Evidence Act. That is all you need to do. Even nowadays, before now, when you want to serve court processes, if Mr. Olumide defames me on Facebook and I don't know his address, my reliefs are limited. I can't start looking for him all over the country to serve him. I don't know where he stays. I don't know where he lives. But now the laws now provide for what we call electronic service. Simpliciter, what it means is that Mr. Olumide has defamed me on Facebook. I can simply do him an email or do him a Facebook message telling him to take notice of the existence of a court proceeding against him in view of the fact that he had defamed me. So we can go on and on and on, but briefly, that is just, how to answer the question which you have posed to me.
All right. I would like to ask, are there legal implications of using this, instead of, I will not use the word social media evidence because you just clarified that, but are there legal implications of this electronic evidence, and how do courts ensure its admissibility in cases?
Thank you. Well, like I have said, to ensure its admissibility, first of all, if you do not comply with the provision of Section 84 of the Evidence Act, your electronic evidence, no matter how convincing it is, will not be admissible. Now, what it means is that the court dwells a lot on authenticity. The court dwells a lot on authenticity. You cannot take a screenshot from Facebook because we have come to terms with the fact that as good as the internet is, as much as we are saying we want to embrace social media, as much as we are saying we want to embrace electronic evidence, what you get is that some people actually explore the terrible sides of the internet. Some people do Photoshop, some people doctor images, some people doctor videos. There are videos you see today that look as authentic as anything, but they're actually doctored. The drafters of the law have come to this realization. And so what they have said is that when you give us electronic evidence, when you attempt to give us electronic evidence, there is a need to comply with Section 84. Section 84 provides for ensuring the authenticity of that document. That is to say, the computer which you used in producing the document, you must tell us about it. The printer which you used, you must tell us about it. You must show that that computer, that printer was functioning very well in the course of you producing or manufacturing that piece of evidence. You must show that the computer was used over a period of time for the same purpose. You must show that that computer has been used over a period of time for the same purpose. What we are saying is that you cannot buy a computer today and just decide that for the purpose of this is what you want to use it for. No, that computer must have been functioning before you stumbled on that piece of evidence which you want the court to rely on, which you are tendering before the court. So that is the way to ensure its admissibility. If you do not produce a certificate of compliance showing that you have complied with Section 84 of the Evidence Act, that piece of evidence will not be admissible, no matter how fantastic it seems to be.
Tomiwa, Fadeyi, because of our time, just in 30 seconds to wrap this conversation up, how do you see social media evolving in its role in legal proceedings over the years? In 30 seconds.
Well, I saw social media has evolved very well. I think we can do better. I am happy that the courts are now embracing the idea of electronic evidence through social media, the idea of electronic service through social media, the idea of virtual proceedings and all of that. Social media has evolved very well, and I think it will evolve more. I think we should embrace it more, really.
All right. Thank you so much for your thoughts this morning. We have to go. Thank you for joining us and for giving us your professional knowledge in that aspect. Enjoy the rest of your day.
Thank you very much.
Right.
And you too. Thank you.